It's my duty.
What do you mean?
All right, good afternoon, everyone. We will call to order the first meeting of the Senate General Laws Committee for 2014. I want to welcome all of our fellow senators back for our first meeting. We figured we would start with something of great interest. And I will just mention as we get started, we have our Senate videographer who always and eternally has permission to record these proceedings. Also today, we have Progress Missouri, that's you?
Yes.
And that's your tripod there?
This one here.
And then we have KOMU, that's the tripod to the left, and KRCG is the tripod to the right. So just to clarify, the policy on recording, anytime that you want to record these proceedings and you want to do that with an audio recording, it's perfectly okay. You don't need to let us know. You don't need to talk to us in advance. If you have a tape recorder, if you have something that is an audio device, you can do that at any hearing, anytime, without letting us know in advance. Any of you that want to do video recording, you do need to let us know 24 hours in advance. And I will just let you know what the policy of this committee has been and will always be. We're bending that policy just a little bit today because it's our first time back in the saddle for 2014. But that is, the Senate videographer will have that position, and then anyone else that's going to video is not going to be setting up tripods, et cetera, et cetera. Anybody else that wants to video record is welcome to do so, but you need to do so in the space that any other private citizen would take up, which means no tripods and things like that. So if you have a handheld device, or if you want to stand back in the corner or something like that, you're welcome to do that. But we're not going to have this committee room become wall-to-wall cameras and videos and things like that so that citizens can't participate because they can't see what's going on. So is that clear? I know most of you probably won't be back repeatedly, but yes.
So am I correct in assuming if we want to take a short video with our iPhone or something that we could do that as members of the press without seeking permission from you?
You know, today we're going to bend these rules a little bit, but it is Senate policy that if you are going to make a video recording that you need to let us know 24 hours in advance.
I see.
So today we're not going to have a fit about it, but for future reference, any audio recording, we don't need to know anything about that. We don't need to be told about it. Video recording, we need to know 24 hours in advance. So today
And
we're.
that includes smartphones?
It does, yeah.
Okay.
So today we're going to be a little more flexible since it's a new year and it's our first meeting. But for future reference, we won't be bending the rule after that. All right. So we will go ahead and why don't we wait? We have a quorum, but we'll wait to call the roll. The way we're going to do this first bill, just so that everybody knows, we are going to actually have what we call an informational hearing. When we get to the end of our time today, which will be straight up 4 o'clock, we'll actually just go into recess. We're not gonna adjourn from this meeting. We're gonna go into recess, and then we're gonna pick it back up next week. So this bill is gonna have 2 hearings, the first one being today, and of course the next one being next week. Today we are limited to now less than 1 hour to hear testimony on this. And by the way,
Kill me.
you guys need to make me a hole so that I can get in and out. I need to be able to get past you. So now we're seeing why the room is too small to have a bunch of tripods in here. So let me just repeat that so that everybody's clear and so that I'm clear about it myself. And that is, this is an informational hearing, and it will continue next week. This week we'll have just under an hour to be able to invest in this. Next week, we're gonna have more time. Today, we're constrained by the fact that the Senate goes in at 4, and so we can't have a committee meeting while the Senate is in session. Next week, we should have, according to the normal way that the schedule goes, we should have quite a bit more time next week, but this week will be limited to just less than an hour. So I want to ask, I'm going to go forward in just a minute. I'm going to quickly go over some of the changes from the bill from last year and this year, and then I'm going to come back up and take the chair and run the committee the rest of the way through. So let me just ask, how many people do we have who plan to testify in favor of the bill? If you would hold your hand up until I've counted you, just so that I can have a little bit of an idea. Those who would testify in favor. 1, 2, 3, 4. Okay, and then how many would be testifying in opposition? Raise your hand. No? Really? How about informational purposes only? Okay. I guess maybe next week is going to be the week where there's gonna be more people here. Okay, so temporarily, I'm going to turn this over to our Vice Chair, Senator Schaaf. Senator Schaaf, just for your information, I will just very quickly go over the changes from last year because we are all, I would assume, intimately familiar with this bill. It received quite a bit of time and debate last year, so I'm just going to kind of go over the changes. I'll be happy to answer any quick questions that there may be, but really today's purpose, more than anything, is to hear from people that would want to speak either in favor or in opposition. So if that's suitable to you, Mr. Vice Chair, we will go on that plane.
Sure.
Yeah, yes.
So at what point are we going to call roll?
Well, I'll tell you what. Why don't we just call roll right now? Because
I would appreciate that.
I think it's going to take me a minute to navigate my way through those cameras, and so while I'm moving to that chair, if you would go ahead and call roll, we'll go from there.
Chairman Nieves,
Here.
Senator Shaw, Libla,
Here.
Romine,
Here.
Sylvie,
Here.
Holzman, Nasheed.
We will now open the hearing on Senate Bill 613, Senator Nieves.
Thank you, Mr. Chairman, members of the General Laws Committee, Senator Brian Nieves of the 26th Senatorial District for the record, and I am here to present to you once again a bill that I think all of us are probably more familiar with than we might even prefer, and that is Senate Bill 613, which was last year's House Bill 436. And you remember everything that happened with that. It is known as the Second Amendment Preservation Act. And what I'm going to do for your benefit, I think probably one of the things that senators of the committee would most want to know, although obviously we won't limit our discussion today to what the changes are, but I would assume one of the things that you good senators would want to know would be what are the differences between this bill and the bill that we voted to pass last year and attempted the override on. So I'm going to just kind of draw your attention to certain pages. If you would like to, just kind of follow along with me on page number 2, on line 38. We've simply changed the old language, just simply used the word orders, where now we've added a few other words just to give further clarification. Executive orders, administrative orders, court orders, rules and regulations, administrative orders, et cetera, et cetera. That's a very, very small change. If you just proceed on over to page 4, this would be a significant change from last year and a change that we hope will help garner more support for the bill, and that is we have removed the references to the Gun Control Act of 1934 and 1968. We have removed those references. Those references, from what we were hearing, gave some people a certain degree of heartburn, and so we have simply removed that language from the bill. Next thing I would bring your attention to on that same page, page 4, down towards the bottom on line 117, sub 6, we now use the word knowingly in the hopes of alleviating some concerns about someone who would unwittingly or accidentally violate this particular provision. Then if you go on to the next page, page 5, there is a, on line 126, it talks about the loser pay provision, and the hope there is to remove the concern about people launching frivolous lawsuits because of this bill, and so the loser pay provision should help with that. If you go down a little further on that same page, line 135, where it talks about law enforcement officers, there was some concern last year that we had heard that people were concerned about the bill kind of forcing or creating confrontations between local law enforcement and federal law enforcement. So we've changed the wording there. You'll notice the word discretionary power. So that should go a long way in alleviating those concerns. And then just a little bit further down, lines 141 and 142, you'll see that we've addressed the concern that some had concerning illegal immigration or enforcing immigration law. If we continue on to page 7 and go down to line 12, you'll notice we've replaced "and shall be required to keep such firearm on his or her person." We've changed that to where now it says "in their personal control." There were some people, of course, this is the portion that's talking about school enforcement officers or school protection officers, and some were concerned that the staff member would have to have the firearm on their person at all times, and so now we say that it has to be in their personal control. A little further down on line 28, same page, page 7, we've changed the amount of time that a school protection officer can detain someone. It used to be 4 hours, it is now 1 hour. Again, just trying to alleviate some of the concerns that people had. If you go on now to pages 8 and 9, at the bottom of page 8, you'll see the section 544.085, and that begins about almost at the bottom of page 8. And so what I wanted to let you know is we are preparing a Senate committee substitute. The substitute will completely remove all of that language. There was some concern about that warrant language causing a single subject challenge. And so if we're going to have a bill that specifically addresses following the Constitution, we just thought it might be a good idea to make absolutely sure that we are following the Constitution. So if you start there just below line 70, where it says 544.085, at the bottom of page 7, and then continue, or excuse me, page 8, and then continue on to page 9, and go all the way down to line 18, just above, where you see 571.012, that entire section in the committee sub will be removed.
Senator,
Yes.
do you mean both sections? You just described 2 sections.
Yes, I'm sorry, Senator. If you look at the portion on page 8, where it starts off with 544.085, that portion will be removed, and then you go on to page 9, where you see about halfway down the page, 544.086 will be removed. So that takes it all the way down to 571.012. So 571.012 begins the portion that will remain in the bill. So we've taken almost all of page 9 out. At the bottom of page 9, where we talk about healthcare professionals, of course, there was some, I think even you, Senator Schaaf, that had some question about the wording from last year. So we believe we've made this wording way better, because now what it says is no healthcare professional licensed in this state shall be required to. So what we're saying now, different from last year, is we're simply saying that the government will not require you as a physician to collect this information, which is entirely different than what we had last year. You'll also notice if you were comparing the bills head-to-head, this is where we took out the language forbidding the publishing of gun owners' names. And so that was one of the provisions that had created some angst with some people, so we completely took that out. And I think we've probably reached the end of any substantive changes. If I remember correctly, that is the end of the changes that we did from last year. The rest of the bill should be the same as what we're familiar with from last year. Yes?
Senator, a question regarding page 10, subsection 2. That language, no healthcare professional may document or otherwise disclose information. That's problematic for me, and I just wondered how come you didn't take that.
I'm sorry, Senator, tell me again where you are. You're on page 10?
Line 8, near the top of the page. Basically, I know what you're trying to do here is a very good thing. There's a tension between, here, the freedom of speech of a healthcare professional and then the ability of a citizen to maintain a firearm. The thing is as a healthcare professional, I take my First Amendment rights very seriously. So to prevent me from documenting information in my medical record, no matter what it is, I should be allowed to document it. I would ask you to consider taking out the words document or otherwise and not allow the perfect to be the enemy of the good.
Well, and Senator, I hope what yourself as well as any other healthcare professionals would notice is in terms of our willingness to address that and our willingness to show that we do honor that relationship is, again, we go to the portion that says that they shall not be required by law, and then on page 10, the word documenting was removed from last year so that so now it says, nothing in this section shall be construed as prohibiting or otherwise restricting a healthcare professional from inquiring about a patient's status as an owner of a firearm and documenting any discussion about medical contraindication of firearms, et cetera, et cetera. So what you see there is at least an attempt to address what you're talking about. And this is one of those fine balancing acts where we have to balance the First Amendment rights of a person who is wanting to document information about another person with the Fourth Amendment rights of wanting to preserve the privacy of a person. So our hope is that we've kind of struck a balance there, and just as hopefully you've seen demonstrated in our actions so far, I would certainly welcome any continued discussions with you, but we're hoping that we've at least made a good faith effort to balance the First Amendment with the Fourth Amendment. There's always this quandary when one amendment kind of wants to trump the other. We try to give them equal billing.
I understand, but we still have a problem. Anyway.
And I'll be happy to work with you.
Does any other senator have any questions? Senator Sylvie.
Thank you, Madam Chairman. Between those two sections, 2 and 3, can you explain to me how they're not straight up contradicting each other?
Are we on page 10?
Right. On page 10, line 8, it says, no healthcare professional licensed in this state may document, yada yada, without a court order. And then in section 3, it says, nothing in this section shall be construed as prohibiting or otherwise restricting a healthcare professional from inquiring about a patient's status as the owner of a firearm and document it.
Right.
So if they may not document without a court order, how are we to construe that any way other than prohibiting them?
If you follow that same sentence, nothing in this section shall be construed as prohibiting or otherwise restricting a healthcare professional from inquiring about a patient's status as an owner of a firearm and documenting any discussion about medical contraindication of access to firearms if such inquiry or documentation is necessitated or medically indicated by the healthcare professional's scope of practice. So in other words, what that's saying is, if the healthcare professional believes that it is within their scope of practice, if it is medically indicated or necessary, then they have the ability to document.
So
So it basically just gives them it gives them a way out of being able to say, in my professional opinion as a doctor, I think it is medically indicated that I would ask and document about this.
Well, I guess my question would be, why is it necessary and what does it do if it says you can't do it unless you have a court order or unless you think it's medically necessary, which I assume every doctor who wants to record that information would say?
Yeah, we're just putting the onus onto the doctor to be able to say, yes, this is something that I believe is indicated for this patient. In other words, I think what we're trying to communicate here is that we don't want just the wholesale willy-nilly document. We don't want to create some sort of a database willy-nilly unless it is medically indicated.
So then is the idea that if an incident should ever end up in court, that the doctor would be required to defend why they thought it was medically necessary to record?
I could see where that would be a possibility, sure. And I believe that's proper, because once again, we're talking about taking a person's right to privacy and possibly violating that right to privacy, which I think is worth putting a little bit of the onus back on the professional to say, okay, I'm not just willy-nilly deciding to collect this information on every patient I see. Instead, as a professional, I am deciding which patients I need this information from and which patients I don't.
Okay, thank you, Mr. Chairman.
I have a follow-up question. On page 10, line 16, starting with document, and it says documenting any discussion about medical contraindication of access to firearms. So that's not saying that I have permission to document the evidence that a given person owns a firearm. It's just only allowing me to document any discussion about medical contraindication of access to firearms, correct?
Okay, so we're still in that same section. Nothing in this section shall be construed as prohibiting or otherwise restricting a healthcare professional from inquiring about a patient's status as an owner of a firearm and documenting any discussion about medical contraindications of access to firearms if such inquiry or documentation is necessitated or medically indicated by the healthcare professional's scope of practice, and such inquiry or documentation does not violate any other state or federal law.
So my point, or my question is, the documentation that this subsection is allowing me is specifically limited to a discussion about medical contraindication of access to firearms in this wording. So my question then is, this doesn't give me any permission to document the fact of who owns a firearm, does it?
I would say that it certainly puts a chilling effect on a healthcare professional just deciding at wholesale that they're going to document that about all their patients. And Senator, Doctor, I would just have to tell you that as an advocate for privacy, this should be something that I would expect. You know, I personally don't see the problem from, I guess you would say, from a privacy standpoint, because I know that you would not just wholesale collect this kind of data on all of your patients. And I would think that any healthcare professional who is actually following the scope of practice and making these decisions based on whether it is medically contraindicated or indicated would never have a problem with this particular section of law.
I think what you're trying to get at here is the electronic medical record that has the blank that says, does anyone in the home own weapons? And they just automatically say, the nurse or somebody's taken the history, does anybody in the home have weapons? And they go, yeah, we have a handgun. Type that in. You don't really want that to happen.
I absolutely don't want that to happen.
Right. And sometimes those electronic medical records might not allow you to move forward unless that blank were filled in. That would really be heinous, wouldn't it? But then on the flip side, let's say that somebody comes in with a hunting accident injury, and they come in and they get a bullet wound in their foot. And you go, how did you receive that bullet wound? Now, you have to remember that the physician, what the physician writes in the medical record is a legal document. I mean, you're supposed to be sort of, you know, documenting some facts that might be used in a court of law. And every doctor knows this. So every doctor is careful to try to put down the correct facts. And so you might say, did you shoot yourself in the foot? No. Who shot you? Well, my friend here. Was it with his gun? Yeah. You know, you want to write these facts down because they matter to people. You don't want to really stop that kind of an interaction, do you?
Maybe a little bit, yeah. Yeah, because, and again, I'm not a physician, and I'm very happy to be educated on why it would be important. See, this talks about, this provision strictly talks about ownership, right? So if a patient presents and they have a gunshot wound, and the doctor says, were you shot? And they say yes, and what kind of gun? It would be pertinent, I would think, for the doctor to maybe know what caliber of gun, or how close to the gun were they, et cetera, et cetera. But I'm not sure that I understand as a layperson how it would ever be important from a medical standpoint for there to be any indication of who actually owns the firearms that it happened with.
But see, the thing about it is under this, the way this is written, if somebody comes in to me as a physician and I'm just writing down stuff that they say, and it doesn't come into my mind that, you know, this section of this law prohibits me from writing down that this guy said that I own the firearm, and I write it, I suddenly have violated the law. And I, as a physician, I don't want to be having to think about whether or not, you know, I'm stepping afoul of some esoteric law about documenting. I want to be free, completely free to document whatever the heck I want to write into my medical record. And so I guess what I'm saying is that I'd probably be much better about this bill if you got rid of the words document or otherwise, so that the physician could actually write whatever the physician thought, but just you couldn't disclose it without somebody's permission. I'd be okay with that probably. But anyway, we will have to discuss this at length later.
Yeah, I think we've shown a willingness to work and bend and
Yes.
be Gumby on this bill.
But I think we know what you're trying to get at, and I agree with that. Any other questions? Seeing none, do you want to?
All right. If it's okay with you, Mr. Chairman, I will come back up and take the chair and. All right, we'll begin to take testimony. We have exactly 30 minutes remaining. And so just in case we have any new additions that have come in since we asked last time, I'm just going to ask the whole question again. How many of you are here to speak in favor of the bill? If you would raise your hand until I've counted you. 1, 2, 3, 4, 5. We've grown that number by 1, I think, since last time. So we have 5 to speak in favor. How many do we have to speak in opposition? 1, 2 in opposition, okay. And so who do we have to speak for informational purposes only? 1. Okay, so that gives us about, how many was there? I lost count. 5, 8. So 8, all right, so that's, yeah, we're gonna do, here's what we're gonna do. We're gonna do 3 minutes, and it's gonna be a strict 3 minutes. So think about what you have to say, and if you realize that you're going to get up here and say "me too," then you might want to wait until next week where we have a little more time flexibility, because we are going to continue with this next week. So I will ask our first person to speak in favor. We're going to flip-flop them. We'll do 1 in favor, 1 opposed, One in favor, one opposed, and then we'll do informational purposes only, and one in favor, one opposed. So who wants to be the first one up to speak in favor for 3 minutes? Don't ever move at once.
Right, I can do my, I'll just do me too, and so you can make that time a little longer.
Okay, well, we're still gonna keep it to 3 minutes because sometimes we have to physically take people away from the microphone. We can try to stay to that, so. Okay, so